Ever found yourself in an argument with an organization where it feels like you're just not speaking the same language? Well, it happens all the time. And sometimes a whole dispute, a really serious one, can boil down to the meaning of a single word. That is exactly what happened here, in a story about one homeowner's quest for a little financial transparency. So, this is where we meet Deborah Mesear, a condo owner in Arizona. She was feeling a bit uneasy about her HOA's finances and, wanted to see the numbers for herself. As she put it in a formal hearing, all she wanted was some checks and balances on how her community's money was being handled. Pretty reasonable, right? So, where did this all kick off? Well, it started with what sounds like a totally normal request. Ms. Mesear just wanted to see the annual audits for her condo association, going back about 5 years. She just wanted to get a handle on the community's financial health. But, as she was about to find out, getting those documents would be anything but simple. So you might be wondering, how does a simple email turn into a full-on legal hearing? Well, it escalated really quickly. In May of 2022, Ms. Mesear sends that first email, radio silence. So she files a formal petition. The association then sends over some documents, but crucially, they weren't the audits she'd asked for. By September, both sides were in a hearing room in front of a judge. And this is the absolute crux of the entire dispute. It all comes down to this one question. Ms. Mesear asked for an audit, but what she got was something called a compilation. Now that might sound like we're just splitting hairs, right? A minor detail, but no. The difference between these two words is huge, and it's the single point that this whole case hinged on. All right, to really get what the judge decided, we've got to put on our amateur accountant hats for a minute. We need to understand the critical difference between these two kinds of financial reports. So let's break it down. What's the real difference here? Okay, check this out. Based on testimony from the hearing, an audit is the real deal. It is an in-depth, line-by-line deep dive where they match up invoices with every expense. It gives you high assurance that everything is accurate, but it's expensive. A compilation? That's more like an overview. In fact, the accountant's own report says they didn't audit or review the financial statements. It's way more limited, but also way, way cheaper. And wow, this chart just puts it in stark perspective, doesn't it? We were talking about $350 for a compilation versus maybe $3,000 for an audit. That's a massive difference in price. You can immediately see why a volunteer HOA board might lean toward the cheaper option if they're legally allowed to. All right, so the stage is set. Let's step inside the hearing room. With those definitions in our back pocket, we can now see how these two totally different ideas about financial transparency were about to clash right in front of the judge. So from Mrs. Mesear's point of view, these compilations just weren't cutting it. During her testimony, she argued they were basically just a balance sheet, and she pointed out that even the CPA's report said you couldn't use it to judge whether the finances were good or bad. For her, this was not real accountability. But then, the association's manager, Carl Westland, he comes in with a totally different take. He laid it out plain and simple. In the world of accounting, an audit, a review, and a compilation are three completely different things. And his crucial point was that the law gives the association the choice to get any one of those. And for years, mostly because of that big price difference, they had chosen the compilation. So you've got two different expectations, two different interpretations. How in the world does a judge decide who's right? Well, in cases like this, you go back to the source, to the exact wording of the law. And in this case, the entire mystery was unlocked by just 4 little words in the Arizona state statute. And here it is. This is the sentence that decided everything. The law says the board has to provide for an annual financial audit, review, or compilation. See that word right there, or. That little 2-letter word is the legal key that unlocks this whole thing. It doesn't demand the most intense option. It gives them a choice. And what that means is, well, it's pretty straightforward. The HOA was not legally required to shell out for a full expensive audit every single year. They just had to pick one of the 3 options from that list in the law. And by getting a compilation, they were technically following the law to the letter. Okay, so with the law laid out so plainly, the judge's job got a lot simpler. Her path to a final verdict was basically set. Let's walk through exactly how she came to her decision, step by step. The judge's logic was really clear and simple. First, the law itself provides 3 distinct options. Second, the judge looked at what the HOA actually did, and yep, they provided compilations for 2017 through 2020. They complied. And then there was the issue of 2021. Well, the petition was just filed too early. The law gives the HOA 180 days after the year ends to get the report done, and she filed before that deadline passed. So you put all that together, the association didn't break the law. And with all that laid out, the final ruling came down.
Bam! Petition dismissed. So even though Ms. Mesear had very valid concerns and really wanted more detailed information, the association had, in fact, met its minimum legal duty under the state law.
So what can we all learn from this? First, and this is a big one, words matter. The little details, a single word like or, can literally change the outcome of everything. Second, you gotta know the lingo. Understanding what terms like audit and compilation actually mean is crucial. Third, remember, where you live is a huge deal. HOA laws in Arizona are different from laws in Florida or California. And finally, timing is absolutely critical. Acting too soon can be just as bad as acting too late. It's wild to think that this whole case came down to one resident wanting clarity and the definition of a single word. It really leaves us with a question we should all be asking in our own communities. The next time you get a financial report from your HOA, are you going to know what it's really telling you? And maybe more importantly, what it isn't?